in the appeal, Lowick Rose and Swynson Limited.
Lord Sumption will explain the judgment of the court.
What happens if a claimant is owed a duty, but the loss arising from the breach of it is suffered by someone else? Can the claimant recover that loss, and if so, in what circumstances? That, in very broad terms, is the question which arose on this appeal. Mr. Michael Hunt is a wealthy investor. He owned and controlled a company called Swynson. Shorn of peripheral details, the facts are that he arranged for Swynson to lend £15 million to a company called EMSL in order to fund a management buyout of an American distributor of medical equipment. The defendants were a firm of accountants retained by Swynson before the transaction was approved to advise on the American business's finances. Their report was negligent. The American business's financial situation was much worse than the report suggested. If the defendant accountants had done their work carefully, Swynson would have appreciated the scale of the financial risks, and the money would never have been lent. Shortly after receiving the loan money, the business deteriorated sharply. EMSL, the borrower, stopped paying interest and failed to repay the loan on the due date. On the facts so far, the accountants would have been liable for any loss suffered by Swynson as a result of their negligence. The measure of Swynson's loss would have been the unrecoverable balance of the loan that it had made to EMSL. However, 2 years after the making of the loan, the situation changed in an important respect. Mr. Hunt, who at that stage still hoped that the American business might trade its way back to solvency, was concerned about having a large non-performing debt on Swynson's balance sheet. It posed tax problems for himself and commercial problems for Swynson, so he personally lent EMSL the money required to pay off its debt to Swynson. This transaction had 2 consequences. The first was that Mr. Hunt personally became EMSL's creditor and therefore bore the risk that the American business would fail. The second was that since Swynson's loan had now been repaid, on the face of it, Swynson had suffered no loss as a result of the accountant's negligence. The loss had in the end been suffered by Mr. Hunt personally. In these proceedings, Mr. Hunt claims that the accountants also owed a duty to him personally and owed him damages representing his own loss. The judge, Mrs. Justice Rose, rejected that argument, and Mr. Hunt has now abandoned it. Instead, he contends that although the loan has been paid off, Swynson can still recover damages, either in its own right or on behalf of himself. His main argument is that the repayment of Swynson's loan by Mr. Hunt personally should be ignored in assessing Swynson's loss, because it was, in the Latin phrase res inter alios acta, which loosely translated means nothing to do with the accountants. Mrs. Justice Rose and the Court of Appeal accepted this argument, but the Supreme Court does not. As a general rule, a claimant cannot recover damages which he has successfully avoided. There is an exception to the general rule for a limited class of benefits which the claimant has received completely independently of the circumstances giving rise to the loss. For example, gifts from third parties, or contractual benefits such as insurance payments or occupational pension entitlements, which the claimant has received because he bought them by his premiums or his work. But the repayment by EMSL of its debt to Swynson was not independent of the circumstances giving rise to the loss. It was intended to, and did, discharge the loan which Swynson made on the accountant's advice. It is impossible to ignore this fact when calculating Swynson's loss as a result of having made that loan in the first place. That brings one to 2 other arguments advanced by Mr. Hunt, both of which failed in the courts below. The first can be shortly dealt with. Mr. Hunt says that Swynson should be entitled to recover damages on behalf of himself, because it was clear that he was the one who would suffer the real loss. This is known as the principle of transferred loss. It applies when the relevant transaction was intended to benefit a third party. But in this case, the relevant transaction is the original retainer of the accountants to advise Swynson about the American business, and that was in no sense intended to benefit Mr. Hunt personally. Finally, and perhaps most controversially, there is an argument about equitable subrogation. This is the issue which the present case has in common with the ITC case just explained by Lord Reed. Equitable subrogation is the principle by which a person, let us call him X, has been unjustly enriched by a payment from the claimant, and the claimant is held to be entitled to stand in the shoes of somebody who has rights against X. The exercise of those rights then enables the claimant to recover the amount of the unjust enrichment. It is a complex principle of equity which serves a valuable function in achieving restorative justice. But in the opinion of this court, the essential fact which brings that principle into play is that the claimant has enriched the defendant by a transaction which is defective in the sense that some significant benefit of the transaction for which the claimant has bargained has failed. The principle doesn't assist Mr. Hunt because he got everything out of the restructuring of Swynson's loan that he was counting on. Swynson's balance sheet was cleaned up, his own tax position was improved, and he acquired a right to repayment from EMSL, which was defeated by the bankruptcy of the American business, but that was a risk which he took with his eyes open. So in the result, the Supreme Court unanimously allows the accountant's appeal.